I'm asking a question for a
Yes.
friend. She wants to file for her mom. She's now a green card holder, but pretty soon she'll be able to apply for a citizenship. So she's asking if she put it in as a green card
You
holder when
can't.
she get upgraded to a
Nah.
citizen.
No, you can't put it. Nope. Can't do it. You got to wait till she's a citizen.
She have to wait
Yep.
until she's a citizen?
Correct.
Okay.
All right. So the day she's a citizen, she can put in for mom.
Okay.
All right.
But I think you could file for someone being a green card holder.
You can, but not a parent. You can only file for a spouse or a child.
If I'm a resident and I want to marry a man who lives in another country, could my 17-year-old, almost 18-year-old file for him as a step-parent because she's living at home?
No, because you can't file for a step parent until you're 21. But if you were to marry him before the child turned 18, and then the child turns 21, yes, the child would be able to file for him as a step parent.
A friend of mine's husband passed away, and they had an interview next month. She's wondering if she should get a lawyer to go to the interview with her. She lives in Alabama.
I would say yes, because the petitioner isn't alive anymore. So you got to transfer it to a widow petition, and you need a lawyer to do that.
And then her follow-up question is, my husband also filed for her son. So the original petitioner's stepson who passed away, and the son is still in Jamaica, but NVC has already notified them that it's been approved. What's the next step for him?
You would, after the mother gets the green card through the widow petition, the mother would have to do a humanitarian waiver, substitute in for the deceased husband, and bring the son up.
Oh, okay, so they don't necessarily have to refile.
They won't have to, no, because if they refile, it's going to be back on the waiting list several years.
Right.
But you have to do a humanitarian waiver and substitute in the mother after she gets her green card.
I'm a U.S. citizen, and my mother lives in the Caribbean. She's a valid U.S. visitor's visa holder. How could I get her to stay and live with me in the United States?
But she's a citizen, the daughter?
So daughter's a citizen, yeah.
Okay, so you have two choices. Mom can come up on a visit for the purposes of visiting. Wait 90 days, you can put in an adjustment for her, or you can just file an I-130 visa petition for her now, and she'll come up to the United States with a green card in about 14 months. All right, so your mother, how old is she?
She's 49.
When will she be 50?
49.
When will she be 50?
I'm sorry?
When will she be 50?
This year.
When? What's her birthday?
August 2.
Okay, is she married?
Yes, she's married.
And she has, your father's not applying for the visa, just your mom.
He also wants to, but the
Okay.
priority is.
All right, so this is what I would say.
My
Does your mom work? Does she own a home?
She don't have a work.
Okay, she doesn't work. How does she support herself?
We send money.
All right, see, that's the problem. Okay, if she was over 50, it's much easier to get a visitor's visa over 50 than under 50. If she was working and she was leaving behind, she was employed and she was leaving behind your father, I would say it's very likely that she would get a visa. The fact that she's not working, she's under 50 years old, they believe that she may not return back to the Philippines, which is why they're not giving her the visa. Okay?
That's why she got denied.
Right. So statistically, if you're over 50 and working, you're likely to return back to the Philippines or whatever country you're from. So that's why I'm saying, I was thinking in my head, let's refile when she's 50. But if you want more advice on how to help her get her visitor's visa, you can hold on, and we can certainly have a consultation and go through what she submitted and see what we could do to make her case stronger if she were to refile for her visitor's visa, and I would do it after she turns 50 years old.
Yes, hi. I just wanted to find out how did the process work for sister to brother. I'm a United States citizen, and I want to file for my brother.
All right, so you would file an I-130 visa petition. In the I-130 visa petition, you have to show you share the same parents. So how do you show you share the same parents? You have your birth certificate and your brother's birth certificate, and you show you both, the mother and the father, hopefully are the same, or at least you share at least the mother on the same birth certificates, and proof that you're a citizen, and you file it.
Okay, even if I am on disability, I can file for him?
Even if you're on disability, you can file for him, absolutely.
And how long a process does it take? How long will it take?
It's right now 10 years, but if you don't do it now, I can guarantee you that when they do change the immigration laws, you'll never be able to do it again. So do
Okay,
it right
but
now.
it take 10 years for him to get a work visa, or would it take 10 years for the papers? Would he be able to get a visa to work?
No, he won't be able to come here for about 10 to 12 years. That's the wait right now for a green card.
If Congress eliminates brother petitioning, sibling petitions, what will happen to us that have already submitted that I-130?
Very good question. I don't have an answer for you, but the government did take your money. They did say they were going to give you a benefit. And if they don't, you don't know what the final legislation is going to be. The final legislation may be that those already in the system may get through. It may not. They may say nobody gets through. And if they say nobody gets through, I would suggest, or I would strongly suggest that there'll be a lot of litigation over that. That government can't accept money from a U.S. citizen. Say we're going to give this U.S. citizen a benefit, which is the benefit is to petition my brother, and then years later say, sorry, we're taking that benefit away, but we're still keeping your money.
I'm calling regarding my stepdad. He, prior to 2008, before he left back to Costa Rica, he was here for about 20 years. Him and my mom, he was here for over 20 years. Him and my mom have been together officially for around that time, over 20 years, but they officially got married back in the year 2000. Long story short, I guess prior to him meeting my mom, I guess he ended up getting pulled over for something in his car, or I guess a broken taillight or something, where basically they saw that he wasn't documented, so they gave him a date to leave. He never left. Mm-hmm. In 2008, he left on his own will.
So he self-deported.
Deported, yeah. After 2008, he ended up leaving on his own will, on his own.
Okay.
Now he's just trying to come back into the state.
What is your Alberto? Are you a citizen?
Yes, I am. My mom he's married to my mother, though. He never legally adopted us, but he raised us.
Okay, but he never. But okay, and when did he marry your mom? When you were under 18?
Yeah. I think it was back in 2000. I'm 26 as of this year.
And you're a U.S. citizen. And when he left 10 years ago, he only left because he had traffic offenses. He didn't have any criminal record, right?
Yeah, no, he never had any criminal. The reason why he left, it was, I guess, he just, his sister was terminally ill, so he wanted to go back home.
All right. So the answer is you're his stepson because he married your mom before you were 18 years old. He met my mom when I was 3.
Yeah,
you can file for him.
I can file for him?
Yeah, you're a U.S. citizen. You're over the age of 21. He has a 10-year bar, both because he left under an order of deportation and because he lived here illegally, but there's waivers for all of that. And we can get him to come back.
Oh, my God. I thought because my mom was the only legally person married to him that only she was the one.
Well, you can do it, too, because you're his stepson. Or your mom can do it, either one.
Tiana said, I'm a permanent resident in the U.S. My 2 grandchildren are 13 and 15, and they came to stay with me, and now, unfortunately, they're out of status. Their mother cannot care for them. How could I get them into legal status? I love your show.
How old are they?
They are 13 and 15, and she's grandma.
So what you would do, Grandma, is you would go to family court in the local county where you live, and you would get legal guardianship for these children. And as part of the legal guardianship process, you will ask a judge to make a special order in that guardianship saying it is not in these 2 children's best interest to be reunited with their mother or their father because of abuse, abandonment, or neglect. If you can prove that and get a family court judge to make that order, and family court guardianships only take a couple months, it's very, very fast. The children are now considered under the law abandoned in the United States. They're now being cared for by a guardian who happens to be their grandmother, but it could be anybody. And now they can apply for something called the Special Immigrant Juvenile Petition and get their green cards immediately. That would be the fastest way. So yes, there's something you can do. There's something you should do, and we can certainly help you do it.